We have a very representative roundtable today, which includes people from organizations that have fallen victims of hostile takeovers. We have people from business associations, lawyers, and legal experts. I think this is a question of high importance and relevance for the country, and I would like to now give the floor for a welcoming introduction to Ms. Olga Solonevych, head of the association Business Against Raiders. Thank you for coming to this not really round table to discuss this issue. We all know that hostile takeovers is a serious problem, the one of the national scale, which is highly detrimental for the national economy, as it cuts short ways of investments into our country. And this is a painful and unwelcome experience. I'm fallen victim of hostile takeover time ago, and I've been fighting rather fruitlessly in courts for 4 years in a row now. And it was one of the incentives for me to also address wider community in the country with these issues, with these questions. We established a website. We launched pickets of the building that I had taken away from me. The building now hosts the World Bank office now, and we called upon the bank to not pay rental payments to the illegal owner of the building in protest against that takeover. I think I've been doing everything I can in this regard. I do like the phrase by an English philosopher and politician of 18th century who said that everything which is necessary for the evil to triumph is the inaction of scrupulous people. This is why I call upon everyone, every scrupulous person, not to keep silent and to step up our concerted efforts against that. We need to really relay to our politicians, to our government officials, the message about the serious nature of the problem and of the need to counter it. Thank you, Olga. I would like to start exactly where Olga has ended her initial statement. And she did say about the need to attract attention of politicians and officials to the problem. We would really like to focus our attention here at this roundtable discussion on matters of hostile takeovers and corruptions seen as national scale problems. And this is why I want to address representatives of companies to ask them about their experiences with attempts of hostile takeovers against their properties. And we'd also like to hear comments from our legal councils about potential problems in the legislation and what should be changed in the legislation, what should be in the agenda of our communication with politicians. Now the mic is free for everyone willing to speak. Thank you. I'm Vitaliy Mahinchuk. I represent Interlizinvest, and I represent a legal counsel company, Gestas, as well. The problem raised by Ms. Olga is the one of hostile takeovers, and let us be clear, it is about really an offense against corporate rights, corporate ownership rights. There were some early attempts on government policy in this regard. There were changes made in June 2011, which exactly okayed alienation of certain corporate rights by simple written document, by a writ. And actually since that time there is no need for any notary certification of ownership shares in a company. And my client Interlizinvest had visitors this October who came to the company to say this company is not yours. We checked with the registry and there was a number of alienations and the company really changed owners. But the whole range of alienation attempts have been based on a simple piece of paper with just blank statement that the company was sold. That way a business worth $100 million was simply traded. So it's not about really raiders, it's just petty criminals who can come to change the whole situation by stating in writing the fact that they have sold given company to someone, to John Doe, to a third party. And it is impossible to ascertain or certify signatures of those persons for the benefit of whom the company was traded. If you go to court, you may have to spend months, if not years. And actually this is done as a series of alienations and takeovers, which brings the company ultimately to some tax haven or offshore area. And that way it is possible now to sell practically every company without notary certification. And given that notary officers are not the controlling authority in this case, and the company is not authorized to verify the correctness of registry entries and related documents, so the legal deed can be issued to pretend everything has been legal. In my case, the Interlizinvest, the company tried to address the state security services, the Ministry of Internal Affairs, other institutions, and it was told to wait until situation becomes more clear. Despite Maidan, despite Euromaidan, and all such developments, nothing has really changed. The process may take years to finally get to the crux of the matter. And we have a number of railroad cars that are now operated by some other company. We have loan facilities opened by that company in our name with European banks. So this nightmare was all started with the law to simplify and improve business environment in Ukraine. And we see the real results from that. So I think the situation looks pretty much the same that Olga had. Thank you. I'd like to take this occasion to represent other people at the table. We have Vitaliy Mahinchuk, Interlizinvest, Dmytro Kichmarenko from Brovary Terminal Ltd, and Oleksandr Appelhans from Germedtex. These are company representatives. Lawyers include Oleksiy, Sluch, Vasyl, Kysil and Partners, Kateryna, Zvyagina from Arzinger, Arseniy, Miliutin from Afanasiev and Partners, and Egorov from the EBA. Would you like to comment on that?
Leonid, Antonenko. I was requested to comment by Kyiv Post, and last week I commented on the situation without any special access to the documents, only to the publicly known information. As far as I understand, this is not just the problem of the contract about transfer of shares. I believe that there's the problem that the registrator should request proper package of documentation from non-resident company, and those documents should be translated, legalized, apostilled, etc. I believe that since we're speaking about non-resident, then there are a lot of requirements existent in current legislation which require state registrator to take a lot of checks of those documents. Then there should be power of attorney from non-resident to the resident company to undertake such a action. Actually, there are mechanisms allowing non-resident company to protect itself. That's why I do not think that the root of the problem was in the legislation which was mentioned by my colleague. I believe that the problem is in the system in itself, when the entire package of documentation could be doctored some way, or could be faked, and when the authorities are tolerant to this situation, then it is possible to fake and to doctor any types of documents. But nevertheless, I would like to mention that trying to simplify business work in Ukraine, we try to borrow from the developed jurisdiction that mechanism, that structures, and which could function under conditions of the well-developed enforcement system. While here in jurisdictions where enforcement is very weak, it is dangerous to borrow such mechanisms and procedures. If you take not just the substitution or change in the articles of association, and take only the appointment of new CEO to the board or president of the board, we understand that it is quite easy simply to you can quietly and very easily change the head of the board, chairman of the board of the company, and because the idea is good to simplify running business, you do not need a company seal. You can do this without any formalities, but you are right. In 95%, it is a simplification of procedure, which is very useful. But for the cases like we are discussing today, for such cases in developed countries, these marginal types of behavior, these criminal types of behavior, these are types of behavior which are supervised and controlled by enforcement agencies. While in Ukraine, this enforcement is not done. Actually, this enforcement system does not work in Ukraine. That's why we need to find a balance. And this could be counterbalanced with either notarization of the agreement. As a lawyers, we would like to give the companies an option. The companies should have the right to establish the rules of the game for their partners inside the company, requirements to the minutes of the shareholders' meetings could be established by the company. Your problem is let us request comments from other participants. Maybe you will describe the problems of the companies with foreign capital. We would like to understand what are the scale of the problem and what are the threat for the business in this country. I am Oleksandr Appelhans. I'm a citizen of Germany, but I've been living in Ukraine, in Odessa, for 5 years now, and I have my residence certificate. I had a lab which undertook genetics analysis of different materials and grains, and so everything started with the visits of anti-criminal unit from the law enforcement agencies. Then my documentation was expropriated, and then I've got a suggestion from a big bank to sell my business. Although we were never asked questions about my business, we always were asked about surrounding companies, related companies, and at that time I made a decision to sell the green unit of my business, and I revealed that I was under surveillance of the security service of that Finn bank. I rejected to sign up in the register, but I found out that both signatures were faked and they were doctored up. That all the documents in state register were doctored, because at that time we were absent in Odessa when those signatures were made. We addressed to the Prime Minister, to Ms. Kysil from Entrepreneurial Committee, from Chamber of Commerce. Even German ambassador came 2 times, but German counselor in Odessa did not support us. That is, we have got several responses from State Register, from Odessa branch of State Register, from the Ministry of the Interior. They just inherited the arguments from the previous courts, they mentioned that you are under this pressing because the companies around you are under investigation. And when after Maidan, I congratulated all people around me with the state where the rule of law, and some of surrounding people, they remain skeptical. And now I see that the skepticism was well grounded. Now, European Business Association, German ambassador, they understood the situation. In the prosecutor's office, I have not found understanding yet. Did you try to protect your rights in the in courts? I visited Mr. Miliutin in Odessa representation rep office. I tried to express my protest via mass media. That is to make psychological pressure, because my wife and me, we both understand that that we cannot trust courts. If I'm right, then you have a company with foreign investments. And did you apply to Terminal Brovary? I would ask how the familiarization with such stories influence foreign investors.
Thank you for the invitation. My name is Dmytro Kichmarenko. I represent the Secure Property Public Company, and a couple of years ago, this company bought a group with assets here in Ukraine, and it has plans of conducting its business here in this country. And surely these stories, like the one we've just heard, they are hardly to bring any more optimism in the hearts of foreign investors in Ukraine. In absence of guarantees whatsoever for them of having their money and revenues back, also because of really the current position in many bodies of government. I hope it was that position, not is. But yet I think it might be premature to speak of any serious improvements of power. Anyway, speaking of previous experience with the past government, when the judiciary was being not the system of courts, but an extension arm of the executive, and when the prosecution office and local police were just instruments of really exploiting businesses. This really brought a huge question before investors of whether to go in Ukraine or not. Time ago, we also had some attempts to earn something at us, at our cost, though my story may not be as bad as the one we have heard already here. Anyway, in my story, you will find certain characteristic feature that the previous management of the company did participate in that. It sold the company. It did participate in this attempt of squeezing some money from the new investor in the company. And though the attempts ultimately failed, some criminal cases were opened also against us. Though unfounded, there were attempts to really put the terminal in Brovary under arrest. It was not successful as well. There were some litigations, also with involvement of the previous director, who, having understood the farcical situation he was in, he took all the stamps of sales of the company and went hiding. Yet at the same time, he signed some documents, some acceptance documents for some works as they've done. And these documents were served to the court in an attempt to launch criminal investigation against us. Initially, they were a bit successful in that, but ultimately the case was dropped. Thank you. It's really a pleasure to hear that at last some of these attempts have failed, but still, you and your company, do you consider any possibility or option of investing into other objects in Ukraine, or you prefer to wait for investors' reactions? Actually, I'm not the one who makes decisions on making investments in a given country. I'm more dealing with businesses of the shareholders here in Ukraine. But the question is how the shareholders regard the situation in Ukraine. And now they're kind of waiting for some changes because there is no stability in the country, particularly the one related in relation to the recent developments we've been having here. Our investor does consider some options of expanding its business in Ukraine, of purchasing certain assets which might really bring the desired return on these investments. But at this moment, at least, we do not consider any new assets to be developed further here in Ukraine. Thank you, Dmytro. Maybe we can hear to some comments from our legal experts, because Leonid first mentioned the problem as more legislative, a procedural one, about some slacks in the legislation that can be used by unscrupulous people. And there are other colleagues who say that the problem in the nutshell is in the possibility to protect one's right in either the judiciary or in the local police. Maybe our other experts share their vision of the situation. Thank you. I'm Arseniy Miliutin from the legal counsel company Egorov, Puginsky, Afanasiev and Partners LLP. I would support Leonid by saying that the problem of hostile takeovers is the problem of the lack of action, actually, from both the judiciary and the law enforcement, because these bodies do not work the way they have been intended to. And some things that Vitaliy mentioned, speaking of regulatory procedural slacks, I would not put them as really reasons behind illicit illegal takeovers. There can be many instruments that these unscrupulous guys can use, and things can be even forged, be it a notary agreement or other sorts of documents. Say in the story of TVI channel, they even managed to forge a power of attorney issued somewhere abroad, one of the top-rank, high-profile cases related to the takeover of Ukraine's superstore. They had 90% of their shares belonging to an Irish bank, yet still the raiders managed to manage the property for a year and a half, stealing some $15 million from the legal owners, and there was no question of any transfer of shares or assets or something. Our clients did continue as the owner of the property. Yet the scheme was simple and efficient. When after a conflict with the then manager of the superstore, so the shareholders decided to sack him, and that brought a range of cases filed to commercial courts from a shareholder who had just one share in the company and who appealed to be linked to that now sacked manager. Because of that, the courts issued a number of writs prohibiting any changes in the register of the company and documents of the company, which helped retain this, though sacked, the manager at his position, and within which he was able to really steal $15 million from the company. And in this case, we clearly see courts as complicit to these illegal activities. That is to say that the whole issue of hostile takeovers in our country really boils down to problems with law enforcement and problems with the judiciary. As in my case, despite our client was the Irish State Bank, it didn't help. In Ireland, in the Northern Ireland, in the city of Belfast, our colleagues, legal counsels, addressed the court and got a writ from an Irish court. They managed to have it by night already. So without going into much detail, I can tell you that this writ was made within hours at night when they woke up that judge to seek this writ, just to compare how their court system works there and our judiciary here. So after the writ was obtained, we managed to bring a couple of Ukrainian raiders to responsibility under the Irish law, and they received some years behind bars or some heavy financial fines. So until we have a truly independent court that won't work to the benefit of either of the parties, we won't succeed. And until recently, our courts were just really an arm of the executive in the country, and they really fully complied with what the executive wanted from them. So until we make our judiciary independent, it will continue.
Oleksiy, Sluch, Vasyl, Kysil and partners, I would like to support this position that unfortunately both judiciary and enforcement systems in our country do not work. I would like to mention the case of Ms. Solonevych. She was excluded from Lira 2000 limited liability company based on the decision of joint shareholders meeting, and in this case all the documentation was falsified. And even when she appealed to court and the court expertise was held, nevertheless, this ended with nothing, with no result. That is, we do not see any political will to curb unjust courts and corruption. Also, I believe that the law on anti-offshore law, I believe that it is useless law, unfortunately, because nobody knows how to implement it, how to find final beneficiaries, how to bring to light our government officials and to understand how much do they possess in offshore companies. Actually, this law won't allow us to see. I'm from Arzinger. I'm Kateryna Zvyagina. I would like to mention that law, which was passed on October 14th, which will come to force on November 25th. I would like to comment on this law. The objective of this law is of a very good nature, and it may seem that the law is very useful, and the law will and many businesses will work in Ukraine, not going offshore. The entire anti-corruption package is aimed at this, the law on the National Anti-Corruption Bureau and this law, which I just mentioned. They both will work improperly. They provide that the final beneficiary of a company should be disclosed to the state register, and fines are provided for this in the amount not higher than 15,000 of hryvnia. At the very beginning, there was criminal responsibility introduced for such a violation of the law, that is non-disclosure of the final beneficiary. But actually, you can pay fine, which is not very high, and not disclose your final beneficiary. From the very beginning, the objective is quite good, and everybody in this country understand that it is needed. FATFA and directives, they require this law to exist, but I have doubts how it will be implemented. Also, I would like to draw attention to this anti-corruption package of laws. They introduce requirements to the legal entities. For example, the law on counteraction to corruption, which was passed on October 23rd. It has requirements about anti-corruption policy that legal entities and authorized persons should implement such anti-corruption policy. This is much applied to the public procurement procedures, and a company has to have such anti-corruption policy in place on the website, and the labor contracts should have these provisions. At a first glance, these are positive novelties. And if to analyze all the provisions of this anti-corruption package, you will see them positively. But whether there are any practical improvements after passage of these laws, we do not have positive moves as of today because those laws will come into force in late November. As far as I know, registrators by now do not know how they will request information about final beneficiaries from the companies and how they will verify this information. We believe that this information might be false on one hand. On the other hand, the registrators need to look for this, and the authorized company which has to register this new company with a registrator, they have to find out about this final beneficiary with itself because they are responsible for this issue. The hostile takeover issue is a comprehensive problem. I just came back from a meeting of the working group of the members of parliament. They are discussing coalition agreement, and on the framework they discuss protection of the investors' rights on the framework of the Association of Lawyers of Ukraine and Professional Association of Registrators and Depositors, and we have developed our recommendations to the coalition agreement and described this problem of hostile takeovers. This one page of our recommendations is a result of negotiations of all interested stakeholders. We had dozens of meetings, dozens of interviews, dozens of publications, and EBA representative is a witness that a huge work undertaken. And all this huge work was aimed at inclusion of this aspect of hostile takeovers into the coalition agreement. As a representative of Samopomich Self-Assistance Party, I was a representative in this discussion on coalition agreement. On the one hand, the hostile takeovers problem is related to the weak judiciary system and enforcement system. On the other hand, it is related to the poor quality of corporate law. And I would like to comment, representatives of a proprietor who lost his share in the liability company, they know that it is possible to exclude a participant in liability company without any consent from this person. And there was mentioned that the interested party was not invited to the meeting where he was excluded, but even if she would be present, she would be excluded anyway. This is an extremely obsolete provision in our legislation. We mentioned that participant of the or shareholder of the company could be excluded from the owners based on the very special grounds. That is, you should allow people to come to agreement even beforehand when establishing the company. They should come to agreement that when you will be excluded from our company, you will be compensated for this, or you are ready to go to courts in their situations. And what court is liable to establish the size of the compensation? And actually, all these issues are not optional; they are very important. These are the reasons why people do not trust the court system. We do not have clients to whom we would like to recommend to run business in Ukraine. There is much spoken about the simplicity of running business in Ukraine. It is not very difficult to register a company. It could be done very simply. But if you want to be protected with your company, you should go somewhere, to Cyprus, to Luxembourg, to the Netherlands. There are a lot of jurisdictions where you can come to agreement beforehand, before establishing the company, and be sure that judiciary will be able to protect you. Your rights. But before coming to judiciary system, before coming to court, we should establish a system when people will be sure that they will be able to come to agreement. We wrote this at one page, but unfortunately we were not heard because people are not ready to work at the level of principles. If you need help, aid yourself. Even these very simple principles, they are opposed. When they say, let us pass the law on corporate responsibility, it's not the solution to our problem. Then corruption, the problem of corruption and anti-corruption law. The package of anti-corruption law was passed in a package with lustration, in the context of lustration legislation. I suggested alternative draft law. The laws which were passed, they do not respond to our problems, because the Ministry of Justice did not see corruption issues as immediate issues. In the Ministry of Justice, they drafted quality anti-corruption legislation, which comes to force in a year, 2 or even more years. For example, the law on lifestyle monitoring, it changes radically requirements to the level of personal income. Why judges take unjust decisions? Because they have material responsibility. If they will be deprived from the right to spend this money on their needs or the needs of their family, they won't agree with these revenues. There should be legalized requirements to require income to declare expenses of the judges. Unfortunately, more radical requirements which exist in the Eastern European countries, and all this resulted a very unjust law on lustration, and very moderate legislation about declaration of expenses, which comes to force from April 2016, when judges and officials will start declaring their expenses and their costs of 2 years later. This approach could be taken in France or Norway, but not in today's Ukraine. This is one of big mistake. The next mistake which they have done, their approach was the surface, so to say, approach. They try to overcome offshore incomes, not suggesting any solutions to the to this problem. The norm, the provision should be formulated in different way. A judge, an official, a minister should declare to the public that this judge, official, bureaucrat does not own or does not have any interest in offshore company. If this statement appears to be incorrect, then he should be brought responsible for this. While in our legislation we simply imposed a fine for incorrect information. That is, we simply imposed a small tax on offshore business or declaration of income from government bureaucrats. They need not declare that they have interests in foreign companies. They have to declare their corporate rights in Ukrainian companies. This would not work in Ukrainian conditions. That's why solution to this complicated problem should be that those people making responsible decisions in the government should be should listen finally to the civil society, while civil society should realize that we cannot find very radical solutions to the huge problems, because neither illustration nor moderate anti-corruption legislation won't allow us to resolve the problem.
That is, you ought to say that it might not be enough political, say, will of the current government, or there is no such will to change the situation. Unfortunately not. For the past half year, when we discussed the rules, and we called these rules actually the illustration rules, when government officials could be sacked without any explanations or reasonings, which goes against European standards, European norms, and it will most surely be appealed against in either the Constitutional Court or in the European Court for Human Rights. We mentioned these risks, but civil society activists would not hear us. They thought that we were just siding with the old-timers, and they were for this radical agenda that they have now. On the other hand, our suggestions regarding declaration of income were considered pretty much radical. And what we wanted to state is that people do seldom notify real market prices on properties and assets they buy. There are some fiscal aspects to it. We know that there should be some valuation of properties or assets with the involvement of certified valuators before we come up with real market value. And this is the amount that we should use for the sake of declaring our income. In the same time, and parallel to that, we still have like formal evaluation used by government officials. We speak about it for 6 months already, and we think that It is not correct, entirely not correct, to have these new rules implemented since 2016, as well as we think it is incorrect for letting this possibility for owners to say publicly that they were just using the property, that they do not own this property. This is wrong, really. We know how inventive people can be when it comes to declaring their ownership and their property. And we should be able to launch investigation in any suspicious case. There should be resources available from the government to pay enough salaries to those investigators. These are the main premises of us. Unfortunately, we haven't been heard until now, and thank you for giving us this possibility of expressing our vision. Unfortunately, everything we have heard so far here speaks of really incapacity of businesses to protect their interests, despite their attempts to address courts, the governments, the media, the public, etc. So the key question is, what should we do next? This is a universal question for everyone. How should we proceed from here? It was Olga who started this discussion, who called for other businesses to join her efforts. Maybe, Olga, you will tell us now of some practical steps to be taken now to bring their attention and to change the situation, if even slowly and step by step. First of all, I would tell you that the publicity of the prosecution, the General Prosecution Office, should be stated really publicly, even on their website, and there should be information regarding any cases under consideration by the prosecution authority that states this public impartiality. So it is not just about having the list of companies suspected of doing something. You know, I would like to add to here, we have a really proactive civic society of the people willing to take to Maidan, to give their lives for the improvements of their country. But on the other hand, we have a team of experts who are not used to using weapons, who rather prefer a very specific and in-depth work done with serious documents. But the other side of this medal is that this work should be paid, and paid decently. In lack of which, experts have no enough incentives to start exerting some substantial pressure on the government. After I returned from these coalition negotiations, I can tell you that people are really not willing to press on the painful spots, fearing certain feedbacks from the population, from the residents. Yes, the reforms are painful and can be painful, and nevertheless they should be implemented. But experts are not ready to integrate into any of this proactive environment to proceed with reforms. They are still used to working in their groups, expert groups, and there is again little incentives for them to do their job. And people who currently sit in the parliament, they can be representatives of some business group interests, or they may be representing the interests of the population, of rank-and-file citizens who know little, if anything, about what buttons are to be pressed and what things have to be done. Unfortunately, we still haven't got a professional group in the country able to exert pressure on the government. I will continue Leonid's idea by saying that there is no person or entity capable of really taking this idea forward and implementing it in reality. The public is in its majority non-competent, not professional enough. And the public may not provide any specific mechanisms. And I think that the deficit of ideas concerns the deficit of ideas of an individual, or better, an entity capable of becoming a vehicle to spur the reforms. And obviously this is a problem in that and with that. So answering the question what to do next, I'd say that people with ideas, they need to go public with their ideas. No one puts the candle under the bed, you know. If someone has an idea of how to mitigate, how to deal further with that, please make these ideas known through such round tables, through the media. We need to fill the public void, if you want. And those in charge of policy and politics, they would find it harder to not notice these ideas if these ideas were made public. Maybe it's another idealistic point of view, but at this moment I see no other viable mechanism of action. A question. Could you describe how the EBA works? Maybe you've got some addresses from your members regarding these problems. Thank you. I'm Yulia Venherovich from the European Business Association, and our association is the one that unifies European and Ukrainian businesses for the sake of protection of their lawful and legal interests. And our practices show that the problem of hostile takeovers is really a relevant one, and we may even speak of a nationwide nature of the problem. This is a problem that brings fear in many company managers, in many potential investors. You asked about the linkage between corruption and hostile takeovers. Yes, they are connected. There is a clear link between them, a causal link. And the problem is a clear result of inefficiency, of underperformance of the state apparatus. Much has been told about that by legal counsels, lawyers, and our EBA members. In the scope of our association, we keep in the legal field and use the instruments and tools provided by the law. First of all, it concerns addresses to relevant government authorities. Whenever a company that is a member of the EBA addresses us with this problem, we try to immediately react to this complaint and see it as one of the strongest indicators of potential success. We try to immediately draw the attention of relevant government authorities to the problem. And surely we may not generalize here or bring up some trends or solutions, because each individual case has individual tools and instruments at play. Besides official communications and addresses to the government, we also try to arrange immediate meetings between government representatives and business representatives to foster some dialogue, to provide for immediate communication between representatives of the executive and people from the business circles who suffered from hostile takeovers. If we are to assess the performance, the efficiency, it surely depends on the political will of the representatives of the executive, and there are differing levels of efficiency in this case. As regards solutions or ways to resolve these matters, these problems, it is necessary as a first-hand priority to first reform the judiciary to make it really a strong tool to protect interests of the business. The current judiciary in Ukraine is inefficient, it is biased, and we see it as one of the key reasons for us having this roundtable discussion today. Thank you.
I would like to add, because I would like to support the business association and point out that today judiciary has become one of the mechanisms of hostile takeovers. Look at situations in Odessa, in Brovary, everywhere. This is judiciary which makes reads and thus they manipulate with properties. Currently, the court has become one of those forces which undertake these hostile takeovers, and now we have the authorities which try to play the role when they take revenge against the old so-called corrupt authorities. And unfortunately, the property in this country could not be protected under any conditions. Look at the actors in oil and gas markets. Within a month or two, all the owners in the oil and gas market in Ukraine will be changed. That is, we should do reform the judiciary system. When the tax authorities are mistaken, when law enforcement is mistaken, when everybody is mistaken, the court could become the last point in this dispute. I would like to share my vision as a person who assists foreign investors in running business in Ukraine. I would agree with my colleagues that without independent judiciary, you won't be able to attract investors because they won't feel comfortable in the country. Also, I was just thinking about hostile takeovers and about political will. A hostile takeover is a moment when people try to take everything and then divide everything. Again, we had these examples in our literature, in our classical literature. Those who see the final objective in redivision of property so they will do this all the time. But when people who will be preoccupied with the idea of creating something instead of redivision of something to the top positions in this country, then something will change. Probably the nation which produces its leaders should take time and change this paradigm. not to redivide the property, but to create some property. And in result of this change of paradigm, we will overcome this problem of hostile takeovers. In Kherson oil trading point, they when we tried to prevent hostile takeover, all the documents were in files with the logo of the presidential administration of Ukraine. Okay, so the issue remains in place. Who has to resolve the issue? We should to resolve the issue with the judiciary. Who could be a judge? How the court would like. Everywhere in Europe, legal advisor and attorney has to work for his reputation for years before he or she will be able to become a judge in a court. And in Ukraine, the situation works vice versa. We have been waiting for a reform to be published about. We would like to see the concept of judiciary reform from the president. The president is not a magician. He has the nation which is here now, and you cannot change it overnight. In Ukraine, judges get 10 minimal wages per month, which is defined by the law. This is 2 times more than average wage in the country. This is European standard. The judges in Europe get 2 times more than average wage in Europe. In Romania, this is higher, and Ireland, this is higher. What is the diagnosis? Probably the economy is very much in a shadow. If we compare average wage in Kiev and multiply it by 5 times as in Romania, we would be able to understand what should be real wage for judges. But the problem is that people get wages in the envelopes unofficially, and the president cannot change this. Selection of judges, selection of future judges. When I ask my colleagues who are talented, who are gifted, who are well educated, would you like to go to court, and how much would you like to earn? And they suggest figures which they earn now in private sector, understanding that this wage won't grow from year to year. But this is actually now the judge's wage does not allow neither to take a loan nor to send your children to school. But when you when we compare the wage of judges of $2,000-3,000 to what people earn in the country, we should answer yourselves whether we wish to maintain people, or we wish to build up the state. If we will see the function of the state as the main objective to support the vulnerable people, or we should build up the state. That is, politicians should start a sincere dialogue with the broad public. Without this major shift in the minds of our politicians, we won't go further. As far as I know, Olga recalled businesses to unite and draw attention to this problem, because this is a comprehensive problem and you cannot just resolve it within one night. So whether there is any sense for businesses to unite and to try to lobby for a solution of this problem, what do experts think on this account? It seems to me that today's meeting, to some extent, is like a sketch for this future expert structure, which Leonid mentioned. I believe that we are all interested people. These are patriots of this country who would like to live in this country and to bring up their children and grandchildren here, build up their business here, and develop their business here. That is why let us think maybe we need such a structure to lobby for the solution of this issue. I think there are some outstanding issues. Our business has to come to understanding that its interests are not represented properly in the political spectrum. There are a lot of business groups' interests represented. Those business groups support various political parties, but we do not have representation of business as political platform, and each business is fighting for share in the market and conflicts with the interest of another business. And quite often, businesses are ready to invest to take another share of the market and not ready to invest to resolve, to promote some public interests. The association, the European Business Association, is an example of understanding that lobbying for business interests is needed, that paying member fees, you just not resolve the problems of your business, but you create a situation when experts could be involved, or when they can develop a draft law in the interests of business. Now there is a problem that there are a lot of good ideas in the parliament, but legislators are unable to balance all those ideas and bring together all possible solutions within one draft law. And while parties are ready to pay only for the sake of their interests, that is, we can take a model suggested by business associations and make our own platform. We can make these platforms based on the more focused objectives, we could develop an action plan for those measures which should be included into the draft law in order to improve business conditions. Actually, we have this plan. Now we need to make pressure upon politicians who are now drafting a coalition agreement. I came there representing public organizations which are weak enough as of today, and this pressure should be strengthened. Probably the wrap-up contribution will be from Kateryna and Oleksiy.
It clearly makes sense to unify and join our efforts. There is not just an ABA. There are also other organizations uniting business representatives who can participate, and they provide opinions, and they develop draft legislations, and they try to represent interests of their stakeholders before the parliament. In the parliament, there is an AmCham that unites business representatives, rather qualified ones, by the way, who spend their time free of charge to elaborate initiatives, rather efficient and interesting initiatives developed together with non-residents and based on the knowledge of the local market. And they are really capable of offering solutions. There is also an organization which is not that known on the market. Speaking of some dedicated institutions like Invest in Ukraine, like Venture Capital Attraction Company. They have lawyers, they have auditors, other business representatives who jointly can elaborate really comprehensive solutions or offering some initiatives. So actually, it's just a matter to do something. The key complexity here is that the procedures of submission of a draft legislation and its adoption can be a lengthy one. It may take quite a lot of time. And really, it is also about time that we need for that. So it seems we have come to a joint conclusion that hostile takeovers and corruptions are systemic phenomena that are closely connected, and because of that, they need our concerted actions against them. It's about changing mentality, not just of our top brass in the country, but also of rank-and-file citizens. And there is really small number of people who would not join the civil service because of low salaries. The majority of people that come to civil service go there already knowing how they will and where they will get money. Then there are publicity considerations. The more we speak up, the more we are public, the better our actions will be and the more success we'll have. And lastly, legal protection and legal coverage. Even with distrust in courts, we still need to address them to protect our rights. Otherwise, there will be no progression. I'd like to thank everyone. I'd like to thank all of you, our colleagues, for the opinions you've expressed. And I think we will elaborate a joint communique, and we will send you electronically to join, to comment on that before signing and joining. And we'll try to keep in contact with one another. And before we adjourn, we have a question from the audience that I'd like to hear. I'm a volunteer and Euromaidan participant, and I'd like to give my resume, my summary to that young man who wants judges to have $2,000 salaries. They want the people in the government. They want to get more than that, more than 2,000, and to cope with the problem, we need to fight systemic corruption. I've come across a situation right today when Minister of Interior official, a friend of mine, has been subjected to lustration without any real reasons for that. This law really is not free from faults, and we've stated it as early as in March, because really it offers some unprecedented measures not used anywhere in Europe. It's just a Ukrainian reaction to the deep-rooted problems that we have. And speaking of political will from above, to bring people to responsibility, they also get, say, 5,000 hryvnias. I won't expect someone getting 5,000 hryvnias a month to judge the judge or to illustrate the judge. That way we will have this vicious circle situation. We need just a normal system of incentives for those in the government, in the civil service. And you were right when you said that many people go to work in the civil service and the government already knowing how they will earn their money on top of what they ought to have. Salaries and wages should be commensurable with market levels. And government should be really in a position of getting the best of the best from the market. Thank you. I actually wanted to say a bit other matter of civic control, of civic activism control over the system, on the system. We need to involve the public for that. And there is a plight. My plight as volunteer. I had a talk with Olga, and I've been working to support our armies since the time of Crimea takeover in 26th of February. And I worked with Olga Bogomolets on that. So a more simple, more mundane question is that we have a volunteer 100 that really needs some premises here in Kiev to be able to collect those volunteer contributions from Kievites for our servicemen. And I have a request to my fellow servicemen, from my fellow servicemen on nearby Volnovaha, who needs a power generator, 5 kilowatt power generator for them. And this is my only chance of making this information known to everyone potentially willing to contribute. And as Olga Mikhailovna expressed that will to contribute, to assist, to volunteers, to our military forces, I also address this to her as well. Speaking of changes, we see changes even at the level of road police and at different other levels, but changes are slow indeed. Thank you.